Many foreigners enter marriage in Vietnam with good intentions and incomplete information. They assume that common sense will prevail, that fairness is automatic, that foreign assets remain foreign. In reality, Vietnamese marital law does not operate on assumptions. It operates on default rules. Mistake 1: assuming foreign assets are automatically separate. One of the most common mistakes foreigners make is assuming that assets held overseas are excluded from Vietnamese marital property rules. Under Vietnamese law, the location of the asset is not decisive. Without a marital agreement, foreign income and overseas property can still become subject to joint property analysis. Vietnamese courts focus on when and how an asset was formed, not where it is located. If an asset is acquired during marriage, it may be presumed joint unless proven otherwise. For foreigners with complex portfolios, proving separation without prior documentation is difficult and often contentious. Mistake 2: believing informal agreements are enough. Some couples rely on private understanding between spouses. They believe that verbal agreements or emails will protect their intentions. Under Vietnamese law, marital property arrangements must meet strict formal requirements to be valid. A marital agreement must be in writing, notarized, and compliant with mandatory legal principles. Anything less has no legal effect in court. Good faith without legal form does not survive disputes. Mistake 3: delaying the conversation until after marriage. Many foreigners postpone legal discussions because they want to avoid uncomfortable conversations before the wedding. They assume the issue can be handled later through a postnuptial agreement. This delay significantly reduces available legal options. Once marriage is registered, the statutory marital property regime applies automatically. Rights and obligations begin to form immediately. A postnuptial agreement cannot fully reverse what has already occurred. Mistake 4: using foreign templates without local adaptation. Some foreigners use prenuptial agreements drafted overseas. They assume that a document valid in another jurisdiction will be enforceable in Vietnam. This assumption regularly fails. Vietnamese courts assess agreements based on Vietnamese law, not foreign standards. Language requirements, notarization procedures, and substantive compliance all matter. Without proper localization, foreign templates often collapse at enforcement. Mistake 5: underestimating business exposure. Foreign entrepreneurs frequently overlook how marriage affects business interests. Equity growth, dividends, and reinvested profits during marriage may be treated as joint property. Without a marital agreement, business disputes can become marital disputes. Vietnamese law does not distinguish between passive and active appreciation in a simplistic way. Business growth during marriage can trigger complex classification issues. By the time a dispute arises, restructuring is rarely clean or cost-effective. Mistake 6: confusing prenups with distrust. Some foreigners avoid marital agreements because they fear it signals lack of commitment. In cross-border marriages, this perception is misplaced. Legal clarity is not emotional distance. It is structural alignment. When agreements are avoided, decisions are delegated to default legal rules. Those rules are neutral but impersonal. They do not consider personal intention, cultural context, or financial nuance. Mistake 7: seeking legal advice too late. Many foreigners only consult lawyers after conflict arises. At that stage, options are defensive rather than strategic. Prevention is always more flexible than resolution. These errors are not caused by negligence. They result from unfamiliarity with Vietnamese marital law and cross-border legal interaction. The system rewards early structure and penalizes delayed clarity. Disputes over overseas property. Unexpected claims against business income. Inheritance plans disrupted by marital classification. These outcomes follow predictable legal paths when no agreement exists. A properly structured prenuptial or postnuptial agreement replaces assumptions with certainty. It defines ownership, responsibility, and risk allocation in advance. It transforms potential disputes into managed outcomes. If you are planning to marry in Vietnam without a marital agreement, you are not neutral. You are actively choosing the default legal regime. That choice should be informed, not accidental. For foreigners with international assets or business interests, marriage is a legal event with long-term consequences. Ignoring that reality does not eliminate risk. It simply postpones it. The most serious legal risks in marriage are rarely visible at the beginning. They emerge years later when circumstances change. In Vietnam, informed preparation is the difference between control and correction. If you are planning to marry in Vietnam and have international assets or business interests, do not rely on default rules. Marriage is a legal structure, not just a personal commitment. Before you register your marriage, understand what regime will automatically apply to you. LTS law advises foreign investors and expatriates on compliant marital agreements under Vietnamese law. Visit lts.com.vn for a confidential consultation, and choose preparation over regret.